Hello and welcome everybody. Thank you so much for joining us for today's webinar. As you can see, we're going to be discussing LGBT relationships here in New Jersey after the famous Garden State and Obergefell cases, the rights and responsibilities of people in these relationships, and how to end these relationships procedurally here in New Jersey. Of course, our disclaimer, this presentation contains general information only and does not constitute legal advice. Be sure to direct your specific questions about your own case to a family law attorney. The sections we're going to cover, we're going to do an overview, a history, and current status of LGBT relationships and some frequently asked questions. Ending legal relationships, what are the procedural requirements here in New Jersey? And lastly, some common issues in LGBT divorces and how they're covered here by New Jersey family law. So section 1, an overview, the history and the current status of LGBT relationships here in New Jersey. So the beginnings, back in 2004, the New Jersey legislature drafted the Domestic Partnership Act. Now, this was the first form of legal relationship available to committed same-sex couples here in New Jersey. They're currently available to all couples 62 and older, and prior to 2007 only to all same-sex couples regardless of age. There requires a mutual intent to support one another financially during the relationship, and there must be evidence of financial interdependence. This grants many spousal rights, but it does not create a right to post-relationship partner support, such as alimony or division of marital property. The next step was the 2007 New Jersey Civil Union Act. Now, back in October of 2006 in Lewis v. Harris, the New Jersey Supreme Court decided that same-sex couples in New Jersey must be granted access to all of the same rights and benefits as opposite-sex married couples. The New Jersey legislature responded to this decision by creating the quote-unquote civil union, which at the state level really was identical to marriage, but civil union couples did not receive many federal benefits based on marriage because at that point the federal government did not recognize same-sex marriage or civil unions. Now, statewide success came when in 2013, the U.S. Supreme Court decided in U.S. v. Windsor that agencies of the federal government could not continue denying benefits to same-sex couples legally married in states permitting same-sex marriage. Now, because Windsor didn't apply to civil union couples, in Garden State Equality versus Dow, a New Jersey court decided that same-sex couples in New Jersey must be allowed to marry. And because of that, same-sex couples in New Jersey began to marry on October 21st, 2013. Finally, success across the entire United States came after the decision in Obergefell versus Hodges. That was in June of 2015. The U.S. Supreme Court held that same-sex couples have the fundamental right to marry in all 50 states, and now all states are required to allow same-sex marriages, and same-sex and opposite-sex couples are entitled to all of the same state and federal benefits throughout the United States. So let's look at some frequently asked questions about domestic partnerships, civil unions, and same-sex marriage here in New Jersey. Question: if we were married in another state, must we also marry in New Jersey for New Jersey to recognize our marriage? And the answer is no. Just as with opposite-sex couples, as long as your out-of-state marriage is consistent with New Jersey law and with public policy, New Jersey must and will recognize your marriage as valid. Question: will my New Jersey civil union automatically convert to a marriage? And the answer is no. A civil union couple must apply for and receive a marriage license and engage in a ceremony in order to get their marriage certificate. Civil unions do remain valid, and couples may continue to apply for and enter into new civil unions if they so choose instead of marriage. Question: what will happen to the existing domestic partnership and civil unions of couples who now wish to marry? Well, they will remain intact and they will remain on file with vital statistics here in New Jersey. It's really not necessary to dissolve the partnership or the civil union if you wish to take the step and get married. Question, must my partner and I wait 72 hours for a marriage license if we are already in a civil union? And the answer is yes. All people, including current civil union partners, must comply with the 72-hour waiting period unless you get an emergency waiver granted from a superior court judge. Only currently married couples who wish to renew their vows are exempt from this waiting period. So Section 2, ending the legal relationship. What are the procedural requirements to do that in New Jersey Family Court? So ending the same-sex relationship here in New Jersey, regardless of the type of formation you have, civil union or domestic partnership or a marriage, any couple can end the union in New Jersey as long as at least one partner has been a resident of the state for at least 1 year. Now, all the termination processes are essentially identical, but the paperwork must tell the court the type of partnership or partnerships, if there's more than one, that the couple is seeking to terminate. Now, if you want to file for termination of the partnership in another state, make sure you check the procedural requirements because some states have different residency requirements, some have different grounds for divorce, some states don't recognize domestic partnership or civil union, so they might not have a procedure for ending those relationships legally, and some have special rules that apply to specific types of relationships. So make sure you do your homework and find out what procedures apply to you if you're getting divorce or ending another form of relationship outside of New Jersey. So divorce or dissolution here in New Jersey, what are the grounds? Well, divorce laws in New Jersey are the same regardless of whether the couple is same or opposite sex. Now, grounds for divorce include adultery, desertion, extreme cruelty, irreconcilable differences, and a few others that aren't really used that often. You can see them all at the statute. If you click on that, you can see what all the grounds are. Now, a partner filing a complaint to end a civil union or a domestic partnership can use all of the same grounds as someone filing for divorce. Now, the no-fault divorce. New Jersey is a no-fault state, and we do have a ground called irreconcilable differences, meaning there were problems for at least 6 months without any reasonable prospect of reconciliation, and because of that, you want to terminate the relationship. Now, New Jersey courts permit terminations of civil unions on the basis of irreconcilable differences, even though the statute that talks about grounds for ending civil unions doesn't mention irreconcilable differences specifically. No fault or irreconcilable differences is popular for couples who want to avoid high conflict and long drawn out court procedures, which everybody really should want to avoid. Private mediation, always a great idea. It's a more amicable procedure and resolution. If you and your spouse are close to resolving the issues, consider this to complete your negotiations. You still need to file papers in court, but you can go to mediation first if you choose. It can reduce costs. Remember, the mediator doesn't represent either party. You still may need separate attorneys unless you choose to represent yourselves. Now, you can get more information if you look at our slideshow, Divorce Mediation 101. So beginning the case, filing the papers in court. First, you need the complaint. This is the paperwork that states the facts and the reasons you want to terminate the relationship. The person filing becomes the plaintiff. The court returns the paperwork, complaint, back to plaintiff once it's been filed. The plaintiff serves the spouse with summons and complaint within 10 days, and then the plaintiff files proof of that service to tell the court that the paperwork has been properly served. Now, in response to that, it could be an appearance, it could be an answer, it could be a counterclaim, but the responding spouse becomes the defendant, and the defendant has 35 days after getting the initial paperwork to file some sort of response. Could be an appearance, answer, may include a counterclaim. You also have to file what is called the New Jersey Case Information Statement. Both parties have to file this. It's a financial inventory. It's a snapshot for the court so that the court can look at income and assets and expenses and debts and know really what the financial picture of the relationship is. Once the divorce gets started and all the paperwork is served and responded to, then comes the case management conference and discovery. That case information statement is exchanged and filed with the court. The court schedules a case management conference within 30 days of the answer being filed. The court sets guidelines for discovery, which is a formal exchange of information at that conference. Discovery can include interrogatories, depositions, demands for documents like financial and business records. Now, you can file a motion for a temporary order for support or even for parenting. This is for people who need immediate help from the court during the divorce case. It's called pendente lite, for temporary relief at any time during the divorce, asking for spousal support, child support, temporary orders for custody, and visitation, which is more frequently known today as parenting time. Now, there will be some court-ordered mediation, especially for custody or parenting time disputes. The court will send most cases involving custody or parenting time issues to court-mandated mediation. All cases involving parenting disputes go to a priority track at the case management conference. The judge will set a hearing date within 6 months of the answer to the complaint or the counterclaim. Now, there could be custody investigations and evaluations. There could be ones that go through the court, which are called family division investigations, or there can be private custody evaluations. Now, family division investigations is where the judge can order a social investigation, ask for a best interests investigation of the child. That would include a report, may include home inspections, could also include psychological or functioning assessments, and the judge can also interview the child in chambers. Private custody evaluations are where parents can jointly hire a mental health expert to conduct the investigation and prepare the report, or each parent can hire their own expert. Child custody evaluators must be neutral and follow uniform standards regardless of who hires them. Property distribution or support issues. Many people need help with the distribution of assets or debts or with alimony or child support. Now, they may need to hire financial experts such as accountants or business evaluators or real estate appraisers in order to come to a bottom line about how much an asset, such as a business, is worth. Now, all couples will be required to go to the Marital Early Settlement Panel, and if that doesn't work, to economic mediation. Trials are expensive and they're burdensome not only for the parties but also for the courts. So because of that, New Jersey courts require most divorcing couples to participate in a series of settlement efforts, and they are settlement negotiations, early settlement panel, and then economic mediation. There could also be an intensive settlement conference if all of those other methods don't work. You'll have to go to an all-day settlement conference, and if you still can't settle your matter after the all-day intensive conference, your case goes to trial, and a family court judge will review evidence and hear testimony from you, your spouse, your experts, and any other witnesses that are relevant. You will receive a judgment of divorce with orders that will be final, barring any appeals after the trial. Now, post-divorce changes. Can you change what is ordered or agreed upon in your divorce? Now, child custody and child support orders can be modified until the children are what is called emancipated or deemed to be independent. Most alimony orders also remain changeable under certain conditions, such as changed circumstances. but all modifications require a substantial change in your circumstances. So Section 3, what are some common issues in LGBT divorce here in New Jersey, and how does New Jersey family law play a role? Divorce or civil union dissolutions, major legal issues. So what's covered? Alimony, spousal support, equitable, meaning fair distribution of property and debt, child custody, and child support. Again, for case-specific information specific to your particular issue, always consult with a family law attorney. Legal differences with domestic partnership dissolutions. In domestic partnership dissolutions, there are no alimony claims. There is no equitable distribution of property because there is no marital property or debt that is seen to exist. Ongoing property and financial support claims exist only if there is a valid cohabitation agreement signed by both parties. Now, child custody and child support issues are the same for all separating parents, regardless of relationship status, even if there is no legal partnership. Now, let's talk about alimony. Alimony is more commonly known these days as spousal support. As we talked about earlier, there can be temporary alimony or pendente lite. The purpose is to maintain the status quo during the divorce. Now, after the final judgment of divorce, there are different types of alimony or spousal support, and each type really has a specific purpose. Now, alimony after final judgment of divorce, we talked about those 4 types. Here they are. There's open durational, limited duration, rehabilitative, and reimbursement. Now, awarding alimony in New Jersey, please know that there is no fixed formula, but there are specific factors that a court must look at that are found in the alimony statute, and courts consider all relevant factors. A dependent spouse may receive support for some length of time to replace the lost marital standard of living if the other spouse has the ability to pay, and that's the durational alimony we talked about at the last slide. Now, a spouse who contributed to the other spouse's education or earning power, or who sacrificed education or earning power for the marriage, may be entitled to some form of alimony, and that could be rehabilitative. If you go back, you'll see reimbursement is also a form, and that could be for a spouse who gave up or contributed to the other spouse's career or education. Now, fault is not generally considered relevant. So what does that mean? Well, courts do not generally say because one spouse behaved badly, they have to pay more alimony, or because one spouse was hurt more, they get more alimony. Unless marital monies were spent on, say, an affair, that money could be ordered back into the marital pot, but that's only because the spouse having the affair actually took marital assets, and it wouldn't be fair to distribute a bank account minus those types of monies if they were spent on an affair. But generally, fault is not considered relevant when determining spousal support amount. Now, length of the marriage or of the civil union. Now, the revised alimony statute, the changes that were made a couple years ago, prohibits open durational awards in marriages shorter than 20 years, or durational awards longer than the marriage, absent exceptional circumstances. So if your marriage is shorter than 20 years, you're not going to get alimony for an open duration amount of time. There's also no such thing any longer of permanent alimony. Unless there are exceptional circumstances, the award of alimony is not going to be longer than the marriage. Those exceptional circumstances would be severe disability of one spouse or something along those lines. Now, civil unions and same-sex marriages have not existed for 20 years, so you could see what the sort of impact that would have based on the revised alimony statute and the requirement that no open durational awards be shorter than 20 years. Some dependent spouses may wish to argue that exceptional circumstances require treating the legal union as though it were longer because of this caveat. So some spouses have argued in the lower courts that the time spent living together prior to marriage should be counted for same-sex couples. So division of marital property. Well, what is marital property? Well, property and debt that either or both spouses acquired during a marriage or civil union is subject to equitable or fair distribution. Now, this does not include previously owned property or inherited property or gifts from someone other than your spouse. So what is equitable distribution? Well, as I said earlier, New Jersey equitable distribution requires a fair division of marital property. It's not necessarily a 50-50 split. So what about the length of the marriage or civil union? Well, duration of the marriage is an important factor in determining a fair division of marital property. Now, as with alimony, a court can consider all circumstances, including a list of specific factors found in the divorce statute. If a couple was together for many years before civil unions or marriages were allowed, there may be an argument, just like with the alimony, that other factors are more important than the length of the marriage when dividing up property. So now let's talk about kids and New Jersey child custody. Child custody orders are based on the best interest of the children, not about the gender of either parent. New Jersey custody law is specifically and purposefully gender neutral. So parenting rights, a potential issue in many same-sex partnerships. Many same-sex parents have children that are the legal, natural, or adopted child of only one of the parents. So couples should clarify parental rights as early as possible in their relationships. Now, for more information on parental rights, see our companion presentation, Becoming a Family, Rights and Responsibilities for LGBT Parents. So the psychological parent doctrine, this is a very interesting doctrine that is found in New Jersey law. If you have been co-parenting a child that is not your own natural or adopted child, a New Jersey court will consider what your parenting role has been and whether both you and your partner intended for you to be a parent to the child. So what are the required elements to be a psychological parent? Well, the legal parent has to have consented to and fostered the third party's parent-like relationship with the child. That third party and the child should have lived in the same household. The third party assumed significant responsibility for the child's care, education, and development, and support, financial or otherwise, without any expectation of compensation or return of those monies. And the third party's parent-like role continued for long enough to have established a bonded, dependent, parent-like type of relationship. Now, what are some common arrangements for custody here in New Jersey? Well, there's joint legal custody, which is shared decision-making with one primary residential parent. This is most common. Then there's shared legal and physical custody, which is equal or nearly equal parenting time. This is also common, but it requires above average co-parenting skills. You really need to be able to amicably co-parent with your ex in order for this to work. And then there's sole legal and physical custody. This is unusual unless one parent is really completely absent from the child's life or if there's been some form of abuse or neglect. So what about child support? Well, New Jersey courts all use a child support formula. Both parents have a duty to support their children financially regardless of custody arrangements. So it doesn't matter where the child resides most of the time. Now, of course, where a child lives is factored into the formula, But regardless, both parents have a duty to support financially. So what are the primary factors in determining New Jersey child support? Well, the parents' combined income. It can be imputed if one parent is purposefully not employed or underemployed. The number of children. Each parent's percentage share of combined income. The amount of time children spend with each parent. Now, the non-custodial parent pays support to the custodial parent, but in shared physical custody, either parent could pay support. So when does New Jersey child support end? Well, parental responsibility, as we talked about a little bit earlier, for child support ends when the child is deemed emancipated. Some possible emancipating events are the child reaching age of 18. Now, it's not automatic at 18. The child marrying, the child moving beyond the sphere of influence of the parents. They just simply don't need the financial support of their parents anymore. The child becoming an active member of the armed forces, or if the child is no longer pursuing a full-time college education and is working full-time. Well, if you have absolutely any other questions regarding LGBT relationships, how you can form one, how you can terminate one, or any of the topics that we covered in this presentation, please give us a call. You see our number there, 866-580-8754. You can certainly email us at info@weinbergerlawgroup.com. Again, you should always reach out to a qualified family law attorney to talk about your specific case if you have questions that weren't covered during our presentation today. And as always, you can call us to schedule your free confidential consultation if you want to come in and talk to one of our attorneys. Again, there's our telephone number, 866-580-8754. Visit our website. There's a lot more information there, including blogs about LGBT relationships. Our website is www.wlg.com, or again, shoot us an email. There's our email address there for you. Well, we hope you enjoyed today's presentation. We hope you learned a little bit. And of course, we hope you join us next time for our next webinar. We look forward to meeting with you again. Thanks.